Wonderful.
Okay. Well, good morning, everyone. Welcome to the Board of Behavioral Sciences Policy and Advocacy Committee meeting. Today is February 5th, and the time now is 8:39, almost actually 8:40 a.m. So thank you very much. And for this, we will pass it to Christina Kitamura to help us establish a quorum.
Good morning. Max Disposti,
Here.
Deborah Brown,
Here.
Christina Wong.
Here.
And for the record, Wendy Strack is not present. She may be having some difficulties signing in, but right now we have a quorum.
Thank you very much. So our next agenda item is for its introduction. So we will start with myself, and we will start with the board staff, and I will call your name, and then please introduce yourself. So I'm Christina Wong. I am a LCSW member. And the next, Max.
Max Disposti, public member. Thank you, Christine.
Deborah.
Deborah Brown, public member.
Very good. And Steve? Oh, Steve, are you there?
Yes, technical difficulty. Sorry, got the mute button. Steve Sodergren, Board of Behavioral Sciences, Interim Executive Officer. Good morning.
Thank you. Thank you. Sabina.
Sabina Knight, Legal Counsel for the Board.
Great. And Roseanne.
Roseanne Helms, Legislative Manager for the Board.
And I believe then next is Christina.
Good morning, Christina Kitamura, Administrative Analyst for the Board.
Thank you so much. And I think that's all with the board staff and the board members. And so let's proceed to item number 3, and that is the discussion of practice setting definition. And it's going to be Roseanne, and that is a response to what we talked about last time. So
Yes.
Thank you very much, Roseanne. Take it away.
Yes, it is. So our practice setting definition bill proposal is something that we are currently planning on running. It will be introduced soon. There's a couple of additional items that we felt needed discussion. So what I'm going to do is kind of give a little bit of background on the bill and what it does, and then I'll discuss those items and then present 3 possible options to consider. So the current text of the practice setting bill is shown in attachment A for your review. The purpose of the bill is to provide specific definitions for various types of practice settings. Right now, the law is kind of unclear. There's no specific definition of a private practice. The law only really defines an exempt setting, and there's a lot of other different settings that our licensees and registrants may work in. And so clarifying these is going to provide more information about where trainees may work, what constitutes a private practice, and it will hopefully provide additional opportunities for supervision in private practice settings as well. So the board tried to run this bill last year. Unfortunately, due to the COVID-19 state of emergency, it was not able to proceed. The legislature just had too much on its plate in a limited time to meet, so it was not able to run its full amount of bills last year. So the board decided to direct staff to run the bill again this year. So kind of a summary of what this bill proposal does. Like I said, it classifies all settings into 2 main settings. There's exempt settings, and then there's non-exempt settings. The definition of exempt settings is the same. It's a school, college, university, and a government entity or an institution that's both nonprofit and charitable. And then a non-exempt setting is anything basically that's not an exempt setting. Then the bill goes on to carve out 2 specific definitions that fall under the non-exempt setting umbrella, and that is private practice and professional corporations. And it's felt that these settings need a little bit of additional oversight and additional limits on them due to the lack of oversight that would otherwise occur. The bill goes on to specify that an entity that is licensed or certified by a government regulatory agency to provide healthcare services is not a private practice setting. The bill limits supervisors in any non-exempt setting to 6 individual or triadic supervisees at a time. Previously, the limit was 3 associates per supervisor in a private practice or a professional corporation only. So there's an expansion of the number of supervisees, but then we're extending it to the limit applies to more people. And then it also permits contracted supervisors in a private practice or professional corporation. Right now, contracted supervisors are not allowed. However, the bill does state that in those settings where there's contracted supervisors, the supervisor must provide psychotherapeutic services to clients at the same site as the associate. So that's kind of a summary of what the bill does. Going back to a couple of issues that we've identified that maybe require some further discussion. There's a specific provision of the proposed language that we want to discuss further, and that is the proposed piece of the bill. For example, if you want to look at it, I'm going to state it here, but in 4980.06A4 for MFTs, and then there's also corresponding identical sections for LMFT, for LPCCs and LCSWs. There's a provision that says an entity that is licensed or certified by a government regulatory agency to provide healthcare services shall not be considered a private practice setting. Staff, after some further consideration, believes that as written, the sentence could possibly lead to some possible implementation issues. And then additionally, there's a request by a stakeholder for some additional consideration that kind of ties right into that. And so we're gonna talk about that a little bit next. The stakeholder that expressed a concern was Kaiser Permanente. And the reason that they're having a concern is because they have 3 different kind of separate entities that they employ individuals on. They have Kaiser Foundation Health Plan, which is a nonprofit charitable. So anybody working under Kaiser Health Plan is considered to be working in an exempt setting. They also have Kaiser Foundation Hospitals, which is also a nonprofit charitable, so an exempt setting. And then they also employ individuals under what they call the Permanente Medical Group, and that is a professional corporation. So ASWs working for the Permanente Medical Group, professional corporation arm of Kaiser, believe that it's unfair that they have limits on their required supervision for gaining experience hours toward licensure that other ASWs working under Kaiser's nonprofit arms or their exempt settings do not have. And I've attached, they had sent kind of a document outlining their concern. That's attachment B for your reference. So under the bill proposal, as we've currently got it drafted, the issue would partly but not entirely resolve with the settings definition bill. Under the current proposal, the following would apply to supervisors under associates Kaiser Professional Corporation arm. They would now be able to arrange for contracted supervisors to supervise their associates instead of only having full-time employees to supervise, which is now required. The supervisor would still be required to see clients at the same site as their associate, but would no longer be required to be employed full-time at the site. And then the supervisor would be limited to 6 supervisees per supervisor instead of the current 4. So that's what would, if this bill were to go through as is, that's what would apply. Unless Kaiser could prove that its entities were already licensed by a government agency. And so we'll talk more about that in a minute. The reason that the board puts additional limitations on private practices and professional corporations is because it is tasked with public protection and has determined that these private practices and professional corporations are unlikely to have any other type of oversight. There's no other entity like another government agency that necessarily looking over on them. And so there's more of a concern of associates not having enough oversight or not being supervised properly. There's also a concern about supervisees potentially practicing independently, possibly for financial incentives, things like that in certain types of private practices, which is why the law places additional restrictions on those. So that's kind of an overview of the concerns. And so now I'm going to talk about 3 possible resolutions to that. And so the first thing I'm going to talk about is potential solution 1, which is modify proposed government regulatory agency exemption. So as I mentioned earlier, right now as written, the bill provides that an entity that is licensed or certified by a government regulatory agency to provide health care services shall not be considered a private practice setting. The reasoning behind this adding this allowance is it's thought that if you haven't, and the committee discussed this in kind of a lot of detail. I actually went back and listened to it. We had a really good discussion about it about a year ago. But the thought was that the existing government oversight provides additional public protection so that the licensed or certified entities are not subject to the same concerns about lack of oversight as other private practices. However, in thinking about how we would implement that internally, in terms of our staff knowing that, there's a lot of unknowns. There's a wide range of government entities out there that might offer various types of licensing and certifications. We don't really know what we're going to get. And I don't necessarily know that our staff is in the position to have that expertise to make that determination of how good the oversight is. It's unknown if all of the government agency license or certifications would provide a desired level of oversight to provide public protection, or they're maybe just looking for some specific thing. So one solution to this concern might be to make an amendment narrowing the allowance of facilities licensed by government agencies to only certain government entities, such as saying something like, a facility licensed by the California Department of Public Health or the Department of Healthcare Services should not be considered a private practice setting. I chose those two because those two are pretty common certifications that are pretty extensive. The California Department of Public Health licenses and certifies 11,000 healthcare facilities, such as health agencies, home health agencies, hospices, skilled nursing facilities, and other facility types. And they have a pretty extensive application packet. And I've provided some links to those in case you wanted to take a look at what exactly they do. The one thing that's a little unclear with both of these is the difference between license and certification. I wasn't able to get an answer on the exact difference. So I don't know if we would want to say licensure or licensure and certification. Hopefully maybe somebody has a little bit more expertise on that. The other entity that I offered was the California Department of Healthcare Services. And they license alcohol and drug facilities that provide treatment programs. And so I've also they have an extensive process for licensing for that. So I've added a couple of links that show their different programs and their applications, so what's involved. So if the amendment proposed were accepted to include only licensure by CDPH and DHCS, it would mean that a facility that would normally qualify as a private practice or professional corporation would instead be considered a non-exempt setting if it was licensed by one of those two entities. And so if it was a non-exempt setting, it still wouldn't have the same standards that apply as an exempt setting, but the allowances would be more broad. So supervisors would still be limited to 6 supervisees per supervisor. Supervision must be in person, not via video conferencing. It would not be subject to the requirement for private practices that supervisors must provide services to clients at the same site as their associates. And I think that's kind of a big concern because it's a hurdle for these companies that have the kind of mix across agencies, that they also often have multiple buildings, so it's not technically the same site. So I think that would be a big bonus. Applicants for registration utilizing the 90-day rule could work at the facility as well as trainees. So that would be some of the benefits if that amendment were taken. However, there's a downside too. There's a lot of other government regulatory agencies other than CDPH and DHCS. I found a really interesting report by the California Healthcare Foundation. It was from 2014, but it made some really interesting points. So I've included a link in the packet. And a few key takeaways that I took away from the report that I thought were interesting. They named, in addition to CDPH and DHCS, other agencies that also provide healthcare regulatory oversight, like the Department of Social Services and the Department of Aging. They also indicated that sometimes federal and local governments have a role. And one of the points of the report, they were talking about the frequency, intensity, and resources for the regulatory agency to regulate it is not always the same across agencies. So it can make it difficult, and it does make it very difficult for us to find out exactly what the given government agency is regulating and how well they're doing it. A lot of times they have different levels of resources in order to carry out their role. So that's kind of the pros and cons of potential solution number 1. So I'm going to move on now to potential solution number 2, which is to partially modify language requiring supervisors in their private practice and professional corporations to see clients at the same site as their associates. So under this solution, what I would propose is that we delete the provision in the bill that basically states if an entity is licensed by a government agency to provide services, that it's not considered a private practice. So we delete that. It's not in law now anyway, so we just do away with that, and we go a different route instead. There's a provision that we'd focus on amending instead. And for example, for MFTs, it's in 4980.43.4b, and there's also corresponding sections in the LCSW and LPCC law. And it states that in a private practice or a professional corporation, the supervisor must be employed by or contracted by the associate's employer or be an owner, and provide psychotherapeutic services to clients at the same site as the associate. So a change here is possibly coming anyways. The COVID-19 state of emergency has really changed the landscape of psychotherapy. A lot of it's being done remotely now, and it's raised a lot of questions about associates on that same site requirement. It remains to be seen what's going to happen after the state of emergency passes, if things will go back to the way they were, or if if online therapy is going to be more common. It's probably going to be some hybrid of the two. So we're going to be examining this in the board's telehealth committee, and changes will likely be proposed out of that committee based on the committee's decision over the next year or so. So I looked at an example from another state to see if anything could assist the board's effort in this. Like for Arizona, the supervisor is not required to be employed at the same behavioral health entity as a supervisee, even if it's a private practice, as long as they have can provide a verification that the supervisor and the entity have a written contract, providing the supervisor the same access to the supervisee's records as the employer. So if the supervisor can get the records, then it's acceptable. The client, of course, also has to agree to that. And we're kind of doing something with this in our upcoming supervision regulations, which are running right now. It would need to be tweaked a little bit to include private practices as well if we went forward with this. But the supervision regulations require a written oversight agreement if it's an outside entity, and the employer needs to agree to provide the supervisor access to clinical records of the clients counseled by the supervisee. So we kind of have that coming online soon, hopefully, if those regulations get approved anyways. So overall, changes related to the allowances for supervision via telehealth are possible for the future, but there is still some vetting that needs to be done. So one suggestion would be for now to make a change to that language about the supervision in private practice and professional corporation. So that would look something like requiring in a private practice or professional corporation that the supervisor is employed by or contracted by the associate's employers or as an owner, and that the supervisor provides, and then this is kind of where the amendment comes in. We could say that they provide professional services to the client for the associate's employer, but leave out the same site language. We could say something like they provide psychotherapeutic services for the associate's employer. That sentence is kind of where that amendment might come in if we wanted to kind of tweak the same site requirement so that it doesn't have to be in the same physical building. So that's another possible area where amendments could be made. And then finally, potential solution number 3 is a suggestion that Kaiser Kaiser pointed out, and it's a really interesting model. It has to do with Health and Safety Code, section 128735. And that section, while it does something interesting. Doesn't have anything to do with what the board does, but it has to do with data reporting for health facilities. And it basically, essentially for reporting purposes, is a health facility has to report certain information individually. But if it's part of a group practice run as part of a commonly managed unit, it may report as part of a group and not a separate facility. So basically it allows the things to be done as a whole unit rather than individual. So that might fit in somehow to supervision. I'm not exactly sure how to articulate that. That if we were able to use that concept, it could work here as well. So that's what I have for this item. And so it's a lot of information. I think we'll just open it up from a discussion and go from there.
Thank you very much, Roseanne. This is actually such an amazing research that you have done, and the thoughtful solutions, recommending for the board and the public. And so, I want to open it up, to get the feedback from the board members first. So Max and Deborah, any of you have any? And I think okay, for this time, I think Wendy is on, right? Yeah.
I can see her.
Yes, she's here.
So Wendy, would you introduce yourself to the public first before I open up for the comments?
Hi, sure. Sorry, it's a little bit late. Wendy Strack, public member.
Thank you very much, Wendy. Love to have you here. And so yes, so let's open it up for the board members. Any of the feedback about Roseanne's 3 different solutions?
Well, Max here. Thank you, Christina. Well, I'm really impressed, not surprised, but impressed with this amazing work, Roseanne. I just, it's so overwhelming because as I was reading the documents in preparation of today, I felt almost that each option could be the option. It's more sometimes what we don't know, right? That what we know about the possible consequences. I hear a feedback. I don't know if it's me or someone else, maybe. You guys hear me well? There is a feedback that's okay, perfect. So, so it's hard to say. I mean, honestly, I'm a little bit concerned about the option 3. I know it's the one that fits more what Kaiser would like to see in regards to their own settings, but I always want to be concerned and balanced about especially those settings that they are remote, right? And they have different way of serving people that they don't reflect, an enterprise like Kaiser, that's doing amazing work in their own settings. But I'm a little bit concerned about if all the options on option 3, all the variants of that option have been considered. So I like the option 2 and 1 equally, each offer a different way and solutions. So I'm more really willing to hear more from the public, from the people that we're working with, especially the agency that represent our licensees, to see what they find in these solutions, if there is more that we should add or take away from it. So but I'm really, really taken by the amount of work that's been done on this. And I really thank you, Roseanne, for this work.
And thank you very much, Max. And Deborah, go ahead.
I'd like to ditto what Max just said. Thank you, Roseanne. You always are amazing when trying to explain to us all of the intricacies of everything. And having sat on the exempt committee, and I believe that almost went for 2 years, we looked at so many different scenarios, knowing that other things were going to happen. I mean, there is never on any of our committees an end all to be all. Things keep evolving, things keep changing. And so in light of that, and our biggest concern was, private enterprise. And like Max said, on all 3 of the different options and understanding why Kaiser would want what they have, is there a concern that some of these agencies may be overwhelmed with so many different license boards that it's going to be hard for us to single and come in on what licenses or what agencies that's what I'm afraid of, is then we get down to what agencies are okay and what agencies might not be okay, which licenses are good, but which licenses aren't good enough. Is there going to be, well, if you have 2, you don't need 3, if there's, you know what I'm saying? So of the 3 that you proposed on the modification, the amendment, the 3 that you were talking about, which one do you believe that would be more in line with the discussions of that committee, the exempt and non-exempt committee? Would you say they're in line with and would be able to work within?
My personal opinion, not hearing from stakeholders yet, is that option 2 is the most workable.
Okay.
Especially because of what's recently happened with COVID and telehealth.
Okay. Okay, and telehealth is evolving as well, because you have also a committee looking at telehealth, which this might be a really opportune moment by what we decide here on how we're going to augment that, the exempt and non-exempt, which then can flop on over to the telehealth for them to consider as well at the same time. So we don't duplicate services and then have to have another committee that looks at all the last committee.
That's kind of the spot we're in, is there's a lot of moving parts as things have kind of evolved fast in the last 11 months. So.
Okay. All right. Well, thank you for your input, because I know you've been involved in all of that.
Thank you, Deborah. So, Wendy, you have any input, feedback, comments?
I think I'm kind of along the same track as Max and Deborah. It seems to me like option 2 is sort of the simplest and most logical way to approach it. The other options seem like we're sort of wading into some interesting territory that could have lots of other unintended consequences and things we haven't thought of. So I think where I'm at seems like option 2 is the direction we should pursue for right now. But I also wanted to thank Roseanne for your work. This was an incredibly detailed report and provided us a lot of information, a lot of options, and thank you so much.
Thanks.
You're welcome. I definitely understand that it's a lot of information. It's not easy to digest.
Well, thank you very much, Wendy. So, I have a little deja vu moment, when we talked about, the clause that we put, forth, the reasoning, why we put in private practice, and the non-exempt setting, why the supervisor has to be at the same sites and also providing, the practice. So maybe, Roseanne, maybe you can remind us, that, why at the very first place that we put that in place, and now, the direction of changing it. I just want to kind of like have a little more historical context, and maybe that will open up also, some consideration.
The historical context for the supervisor being on site is to avoid concerns that private practices, they don't have a lot of, there's nothing else other than the board that really oversees them, and there's definitely the potential for them to utilize, they could have a financial incentive to utilize associates instead of hiring more licensees. There's concerns about associates practicing independently. We don't want associates setting up their own shingle and kind of practicing independently of their supervisor. We've put, with the supervision regs, that kind of plays into it too. We're trying to put in more checks and balances so that the supervisor has more responsibilities and both parties are more aware of them. But there's always the potential that, that you have a supervisor that's not as upstanding versus there's a lot that are really, you know, trying to do a good job and train. So it's kind of weighing those two. And like I said, with telehealth, right now we're allowing supervision via video conferencing, and so that's kind of off the table right now, anyways. But it remains to be seen what the landscape looks like, you know, when things go back to normal.
Yes, yes. Thank you so much. I mean, I think this is also important for, you know, for the newer members, you know, to kind of hear, you know, the other side of the story, you know, why it's in place, you know, or, you know, at the very beginning. And so, and thank you so much. And, you know, and I'm actually also interested in the solution 3. You know, now I think also reality is that this particular concern really is very, you know, I mean, it's Kaiser specific, kind of, but it's also really opening up, you know, the medical group, you know, or, you know, the kind of like the mega agency, you know, like Kaiser, you know, that the possibilities of like, you know, like the different setting, you know, will provide a different standard. And so, you know, so that health and safety code, you know, that is a very, very new thing, you know, that first, introduced in, you know, in this meeting. And so I wonder also, you know, what will be the feasibility, you know, of just basically, you know, craft the, you know, the languages and be able to also, you know, have say like medical group, you know, be not excluded and considered, you know, as the, you know, as the, you know, be put in this way, it's, you know, be included as the, you know, in the carve out, you know, category. Yeah, I wonder, you know, how difficult it is. So, you know, so Roseanne, what's your take of it? You know, because it looks like, you know, the recommendation is that, you know, it can be done, right? So I hear a little bit more about from your input.
I think it can be done. I think it's a little more difficult. It's a territory we're more unfamiliar with in terms of what's out there and the different setups of medical groups. I'm not an expert in that. Maybe some of our stakeholders are, I don't know. I couldn't see a great way to, I really liked the idea. I couldn't see a great way to craft the language defining those terms so that our staff would be able to know easily and implement that when they're explaining to people what they can and can't do and doing evaluations.
Right.
So, but I'm definitely interested in hearing from the public if anybody has a different perspective on that one.
Yeah, you know, so I think this is the perfect timing, you know, to open up to the public. And we definitely want to hear, you know, specifically from the stakeholder, you know, who works in that field, you know, that setting, you know, to give us some input. So, so moderator, would you please explain to the public about their comments and the rules and things that they need to know?
Thank you, Madam Chair. So I have opened up the question and answer panel, and throughout this meeting to facilitate public comment, we'll be utilizing the WebEx question and answer feature, which we sometimes refer to as the Q&A. So whenever the committee chair reaches a point in the agenda at which public comment is appropriate, public comment will be requested, and at the committee's direction, I will turn on and announce the opening of the Q&A feature. It is not necessary to identify yourself in order to make a public comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. Once you're unmuted, the member of the public may verbally state their comment. This is not a means to ask questions of the moderator or members of the committee. Such inquiries submitted by this feature will not be answered. If any attendees utilize a profane name, they will not be called upon to prevent members of the public from being subjected to profane language. While you're free to express criticism or negative views for the sake of the members of the public participating on this call, please do not use profane language when making public comments to the committee. There is a 2-minute time limit. I will give you a 15-second warning to let you know when to wrap up. And we are displaying instructions for you to reference. I see we already have someone who has indicated they would like to speak. So we have a Denise Tugade that would like to make a comment. So Denise, I'll let you know when you've been unmuted. And again, remember there is a 2-minute time limit. All right, Denise, you've been unmuted.
Thank you. Denise Tugade with SEIU United Healthcare Workers. We represent 100,000 healthcare workers across the state, largely at large settings like Kaiser, Sutter, Dignity. First off, wanted to thank Roseanne Helms for the incredible, extensive work she's been doing on this, being so responsive and putting together these materials. And wanted to clarify some of the questions around that third policy option. So that was actually recommended by United Healthcare Workers, along with LCSWs who we represent at Kaiser facilities, and really meaning to address this issue where both our LCSWs and ASWs walk back and forth between these buildings and in the Kaiser campus. It's pretty common for these LCSWs to work across, literally just next door. And so they're going back and forth all day. And so it's hard to say, where are they primarily, are they seeing patients at the same site? Technically, are they in the same building? And so we're finding this issue where our ASWs are, completing these hours and not getting them counted. And so they are employees of Kaiser, but of one of these 3 different entities. And the truth is, we're talking about medical groups, and while TPMG is a corporation, it comes under extensive oversight in a very different way. It's regulated in a different way. Like we raised, they have a whole separate section of the Health and Safety Code where they follow additional reporting standards above other facilities. And that section of the Health and Safety Code really covers really these large systems that are integrated like this. And happy to speak more to some of the specifics of it. But thank you all for your consideration. Really appreciate it.
Thank you, Denise. And that is the end of our request for public comment at this time. Would you like me to close the Q&A panel?
Madam Chair, I have a proposal, if it's possible. Since there are not other people speaking, I would like to see if our last speaker, we can add an additional minute so that they can actually elaborate a little bit more, because I think it's really important, if they agree to it, of course. And I think it will be really important to go a little bit deeper on the aspect of the challenges that we were just talking about. I know we heard before from Kaiser, but I think this is a good refresh in lieu of what the work has been done from Roseanne in these possible options. Is that okay?
Absolutely. I think Max will speak my mind. So,
Okay.
so moderator, let's, I think, we can probably invite Denise back and have, Denise to give us, a little bit more elaboration, and yeah. And it looks like, we do have, Josie Baker, who's, willing to, who actually, raise a question. So yeah, so let's, get, Denise to maybe, briefly elaborate, the things that you want to share with the board, and then we can go from there.
Okay, so Denise, you've been unmuted.
Thank you so much, board members, Max and Christina, I appreciate that. And I should add, I'm the government relations advocate for SEIU United Healthcare Workers. Yes, so happy to elaborate. So the section of Health and Safety Code that was proposed here, like I mentioned, really only captures a handful of very unique entities across the state, such as Kaiser. I think certain Cedars-Sinai facilities, like these large kind of multi-part, research and clinical work kind of organizations. So it's actually quite narrow. And that language was put in statute when Kaiser many years ago was forming, and then has been used consistently as the means for regulating any issues around everything from you know, from the reporting that they have to do to certain fines and fees, a lot of different places. And I'm happy to take questions if that's amenable.
So what you're saying, Denise, is that, that actually particular code, was developed along the side of, the mega health agency like Kaiser in order to, to set the standard, for their operation, or, for basically, for how the surface practice.
That's correct. And that definition is quite narrow. So it would not include most medical groups. It would not include most hospitals. It's pretty specific to this kind of entity that's, completely integrated, where, there's a plan and a provider together.
Okay. All right. Any board member, any questions for Denise? And Wendy, go ahead.
So maybe for Denise or Roseanne. So then walk me through, I guess, what the amendment looks like then. Do we just reference this section as like a separate item that, I guess, just kind of walk me through what that amendment looks like, how we reference section into what we already have?
That's an interesting question. So the amendment would look, so the definition, and Denise can correct me, it seems that the definition is in that health and safety code section E2, where it says a health facility that receives a preponderance of its revenue from associated group practice. I mean, we could carve that out in terms of, I would have to look at it a little bit more in terms of, we could carve it out of a private practice, and say that would be treated as a non-exempt setting. I'm a little concerned, maybe Denise could speak to this, is how the board would know if something met that criteria. Like, what is the standard to prove that?
Mm-hmm.
So, Denise, could you speak to that by any chance?
Sure. Like I said, it's a pretty high threshold. You would, I suppose, so like Roseanne mentioned, I would defer to her on where to place it exactly, but that suggestion makes sense. You might need one additional piece of documentation, perhaps, but because these entities already report to, kind of like in option 2, already report to CDPH, there would kind of be this trail of record there as well.
So it sounds like, to me that, Roseanne, in your option 1, to carve out, the two agencies. I mean, this acronym is driving me crazy now. But if it's in the Department of Public Health, right? And that actually, it means that that would actually fit into, part of what you proposed. And if they look that this is actually at a higher threshold, and I think that might be a possibility, because I am also wondering, since Denise, you are from the United Health Worker group, then I suspect that, you said that you represent like what, 11,000, of the social workers, or is it just health workers?
We represent 100,000 healthcare workers across the state, and then a number of them just within the state as well. Specifically.
So maybe you will be the expert for that. So apart from Kaiser, because Kaiser is where we have, so in your understanding, what other type of organization also will be falling into this kind of category? You mentioned about Mount Sinai, and then what else?
And that's really, that's the unique thing about this particular part of the statute, is that it really only encircles maybe 3 major entities across the whole state.
Right. And so that will be Kaiser, and can you name the other 2?
I believe Cedar Sinai, certain facilities, and that's really it. Kaiser NorCal, Kaiser SoCal. It's a very narrow piece of statute to meet the very narrow needs of this very unique organization.
Very good. I mean, this is actually important. Why, the public comments is so important because, I didn't know that, that's actually you consider Kaiser, NorCal and SoCal is actually two separate entities, and then with the Cedars-Sinai. And so, so that might be some good consideration, for the board members, to continue, to consider. Well, thank you so much, Denise, and I so appreciate your expertise and the and the very, very informational opinions and and the knowledge about the regulations. So thank you,
Thank you all. Thank you for your
Yes,
consideration. Happy to stay on and answer any other questions or provide any other additional color commentary. Appreciate it.
thank you. And Sabina, we gotta bring you on, right?
Can you hear me? My hand's up.
I see your hand.
I'll lower it before I forget it was up because
Okay.
I'll do that. I just wanted to interject here. I always say lovely things about our policy and advocacy committee because you guys do all the heavy lifting and do very thoughtful work. And like everybody else said, Roseanne, you're amazing. And lots of hard work is put into these memos and these options. I'm just the wet blanket to parties that just here to remind you a couple things: public protection mandate, and also, let's be mindful of how we integrate other code sections or other regulatory agencies. Because in the future that may change. They may change something. We also don't want to feel or I don't want to say shirk because we're not shirking our responsibilities, but we don't want to rely on other people to do the regulating that we're supposed to be doing.
Yes.
So all of those, obviously there's a lot of factors and variables, and like you guys already said, there's so many moving parts to this. So it's, whether or not there's going to be a perfect solution for everybody involved, we're not sure. Will there ever be a perfect solution? Who knows? But those are all things to keep into consideration.
Absolutely. And you're not the wet blanket, Sabina. we all need to be reminded that, that all the aspects. And I think this is why this discussion is so important, so that we can hear from everybody. And then we come to, a wonderful recommendation. And so thank you, Sabina. And Steve, go ahead.
And I'll come on the administrative side. We do want to be able to make sure that we can actually administer this law. So I'm a big fan of option 2. I think when I look at this, really the crux of what we're trying to do here is, I think for protecting to make sure that the supervisor is really supervising appropriately, irregardless of the site, is that they have some sort of invested interest in the supervisee's performance. So I'm looking at it as, how can we relate that? Do they work for the same company, corporation as the supervisee? Do they have a contract with them? That's something we can actually, as a staff member, easily look for, instead of having to go, like relying on the other regulatory language from other government agencies. We would have to become experts in a lot of different laws to be able to make sure that they're following the correct correct guidelines. So I think option 2, I would say, is a really good. I would be interested to see what people thought of that. I'm sorry, Denise, what you thought of option 2. Would that fit in? Or would that work towards solving the issue that we're having? Do you think?
This is a moderator. I can go ahead and unmute Denise again. I had muted her just to prevent back feedback. So Denise, you've been unmuted.
Oh, thank you. Yes, it does meet our needs, or the needs of our, associate social workers and LCSWs. I guess my only concern is that it might actually be too broad, potentially, but ultimately it does meet the concerns that we have. Thank you.
Very good. Thank you. Wow, I hear all the aspects, and looks like Josie, Miss Josie Baker, welcome back. And looks like you have a question mark on your name. So moderator, would you please unmute Josie?
Thank you, Madam Chair. And Josie, you've been unmuted.
Great, thank you. I mean, I appreciate being given the opportunity to talk, and Denise is really kind of I'm looking to Denise in terms of all of the kind of legal stuff and regulatory wisdom that she has. I guess as somebody that is on the ground, the thing that I would worry about it, just in terms of some of the language, and I know that some of the language is actually going to be addressed in the telehealth committee, but the language around the outside contractor having to work for Kaiser and practice the psychotherapeutic services with them, not just providing supervision, that's tricky, because I don't want to sound like a wet blanket, but I that's not going to happen. Like that wouldn't be a thing. So that would be my concern. And then, of course, the video conferencing option would also be something I would throw in the ring, just in terms of, because we're so spread out and having so many different sites, and if you're one person, how can you be in 5 places, kind of thing. So those would be my 2 considerations. I don't know if it's appropriate right now to be talking about them, but I just thought I'd throw it out there. Thank you again.
Thanks, Josie. Let's see, I do know that, we have the overlap, with the telehealth committee,
Right.
it is the same language, so,
Christina.
yes.
No, I'm sorry, I didn't mean to interrupt you. If you
No,
will.
you
Okay.
go.
I see that what I see from option 2, because I'm really concerned about, we don't want to cut the legs of with other options to the telehealth committee, because there is so much overlap, right? And we don't know how far the telehealth committee is going to go, because obviously they are just starting their work in terms of reimagining and re-elaborating the extent of these relationships between the client and the supervision or the actual therapist. So I feel the option 2 kind of give us, I know like Denise was saying, it appears to be maybe too broad, but at the same time, it gives us a little bit more leverage and more space to work around in the other committee, because they need to make sense, obviously, whatever we come out from the telehealth committee with this. So I feel like I'm a little bit concerned about option 3, but again, I'm not dead on that, just because I'm afraid it limits the work of the other committee in relations to the possibility the telehealth it's going to explore. So I wonder if also through the telehealth committee we will be able to actually, in lieu of what also option 3 is bringing to our attention, to carve out solutions that are closer to that vision as well. So I don't know if it's making sense, but I just want to honor, obviously, the work that our Kaiser members are put into this, and the feedback that we kept receiving for quite some time. So thank you, Josie, as well, for being here. So I hope that makes sense. I'm sure when we go back to the public, to the board meetings, there will be even additional feedback from our associates and board members as well.
Mm-hmm. Right. And Deborah?
If I remember correctly, and Roseanne, please tell me if I did not. I am not. I believe, Steve, you were at the meeting as well. This was when we were down in Orange County, and we were talking about the concern that there could be possibly people who owned these private practices that were not practicers themselves, and that they could create, what's it called, LLCs, and there was no way to to actually regulate them because their intent was never to provide services, but to own the company that would then hire people. So I think that we just need to, do I remember that correctly? That was a major concern.
Yes, we did have that discussion, and it was a concern, and that's why that goes back to, you did a great job of circling back to the public protection component. That is a big concern with private practices. We are doing some things, with the supervision regulations to try to curb that, but there is that concern with private practices that there's that incentive to sort of, own it and then sit back and let the associates do the work. So we want to balance those two.
Right.
Okay. I wanted to make sure that I know that was a real concern, and we had a lengthy conversation with the public about that. And there was a concern that there was really no legislative body that they would have to answer to. So, okay. And I know that, how Kaiser, I don't know if it was Kaiser, and that might not be the case because they're big. And they're not just a company that's just going to hit and run. They're going to be actually providing, but this legislation has got to be broad enough and narrowly tailored enough to capture everybody at the same time, which is difficult. And like Matt said, this is going to flop over to telehealth, and we've got to be open enough to be able to let that slide on over and let them have discussions about that.
So, Deb, I think you also captured what I want to say. So Roseanne, now, what will be, now let's say for, after today's discussion, what will be the next step? Will you take the language to our board meeting and then, maybe educate us?
Yes, in order for the bill to continue to move forward, we need to kind of come up with a proposed language and then take that to the next step would be the March 5th board meeting. We would discuss it there.
Right. And yet it's not completely closing the doors, for the, for the other possible, loopholes, to close out. So I really, would like to continue to, have a united, health workers organization to, have the conversation with Roseanne, because, it is a very specialized group. Yet, I don't, I think the importance not to punish them, and yet, be able to find that, do a little more research, because it's another new thing, right? And so how we can actually, continue to find that, a good way, to entertain the wet blanket, not really, entertain, actually, to really, satisfy our need, for public protection. I think this is a really important thing, and yet not being punitive, for those who are willing to work with, those who have medical conditions. And so, and yet, I don't also want to, I think this is a fine balance. So I think, I think we can vote on, which option that we like, and then, maybe continue to have the conversation. So, yeah. And Wendy, go ahead.
Yeah, I just, I wonder if our action today, do we have to pick from these options, or can the option we take kind of go along with what you were saying, Christina, is kind of direct Roseanne to keep having these conversations and then bring something to the March board meeting? Because there may be a scenario where option 2 and 3 can kind of come together somehow, where we take the definition from the health and safety code, but we make it part of our regulations. So that way, if it changes over there, we still have our definition, and then maybe we bring it in. Maybe there's something that can be done that way. I'm just a little bit, I'm still not quite clear on how that health and safety code would be incorporated into the regulations. So I think it would be helpful between now and our board meeting, if Kaiser and the United Healthcare Workers could work with Roseanne on what that looks like, because I think to move forward on that solution, it's just not quite clear to me right now. But I am intrigued by the narrowness of that statute, because then it sort of helps keep us from kind of upsetting the apple cart in other areas. But I don't, if there's just a way to kind of merge things so that it's all our statutes, but it's narrowly drawn, maybe there's some sort of hybrid thing that could work between now and then.
See, I think our great minds are thinking so alike now. So I would say that, it looks like the direction, and I'm just be very transparent, it's really for the, for the option 2, and also, maybe to have Roseanne to continue to have the conversation, or even to do a little bit more research about the health and safety code, that Kaiser brought up, and really to examine, the potential, consequences, if we include, that, language or whatnot, so I think, I think we're going to a very clear direction that, now we're plugging another hole, and how can we make sure that, either we can, close out the loop, or, or how we can do that. And so Roseanne, I see your hand is up.
Yes. So, okay. In terms of looking at, I do think we need to look a little bit more closely today at the language in option 2 to kind of make sure that, so I can kind of get a gauge of what you're comfortable with. There's a few different things we can do with that. There is the possibility, like under item number 2, we could add some sort of a carve out based on the health and safety code, maybe not referring directly to the health and safety code, but using that definition somehow. But I want to see what you're comfortable with number 2, where we had offered an amendment there, because I want to go into, to be able to go into in order to move the bill forward, we need to be able to go, if possible, we need to go into the board meeting kind of with an idea of what we're going to amend. Otherwise, the bill's just sort of gonna kind of languish and not be able to move forward. So I think what I'm hearing is that you're supportive of recommending that we strike the provision that states an entity that's not licensed or certified by a government agency to provide healthcare services shall not be considered a private practice setting. So I think I'm hearing that we're okay with striking that from the bill because it's kind of overly broad, and then focusing on, if you look in your packet, that 4980.43.4 B1 and 2, where the language says that in a private practice or a professional corporation, you need to be employed by or contracted by the associate's employer or be an owner, and you have to, and then that's kind of, number 2 is kind of where the solution would go, is what are we comfortable with there? Right. So yes, so board members, now we really have to also look at the language. So, so what Roseanne says is that, so what do you guys thought? I like the fact that, so psychotherapeutic, between the word psychotherapeutic and professional, one is, more definitive and the other is just very broad. What is professional services? And yet I'm trying to think about, like, what would be, the middle ground, for those language, right? And so that's one of my feedback. The other thing is, like, striking out to clients at the same site as the associate instead, and change it to, for the associate employer, I'm okay with that. I think that is actually, a good change. That's my feedback. So board members, what do you think? Any hands? So Wendy, go ahead.
I had that same question about professional services, and I would defer to, the clinicians on this call about what that word should be. But professional services could be, an accountant. So, we want to make sure that the right people are overseeing, and I don't know if psychotherapeutic is the right word either, but I would defer to others on that. But I did have a question about that particular phrase there as well.
Right. So, even as broad as mental health services, it might actually be a little bit less narrow, than psychotherapeutic. Mental health services can mean that, you are an administrator and still providing, working in that field, right? And so, it might, I don't know if that will sound better, than psychotherapeutic. It's a little bit broader, not as broad as, professional. So,
Would
Roseanne.
that be licensed as well? Can we reference licensing? Sorry, Roseanne.
No,
Roseanne and then Steve.
What if we said provides clinical psychotherapeutic services for the associate's employer? And then we would interpret the associate's employer, that's broad. So if it's Kaiser, it's Kaiser. We're not looking at all the different branches. It's just, do you provide professional do you provide clinical psychotherapeutic services for the associate's employer?
I think your clinical services, will probably be suffice. Will probably suffice. So, because if you do clinical psychotherapeutic services, it might actually further, well, I take it back. I am kind of like looping myself now. Okay, so Steve, go ahead. I want to hear from you.
Thanks. I think when we were talking about those professional services, what we wanted to make sure is that we weren't discounting, some people, kind of this goes back to where Deborah was talking about, we're talking about in Orange County. You have some clinicians that are excellent supervisors, and they might really only supervise. I mean, they might not be actively participating in doing clinical psychotherapy, but they're excellent resources, and they just decided at this point in their life, they just want to supervise. We don't want to preclude them, especially since it's really tough to get a supervisor, and we want to make sure we have that pool of supervisors. So we're trying to figure out a way, we want to make sure that they are actively engaged with that employer somehow. Could we say clinical because it still technically is clinical services because they are supervising the, I don't know if that's good enough, but that's what we were looking at.
There's also the requirement for the supervisor, to have, that clinic to practice, 2 years within the 5 years period.
That's true, actually, yeah. That's a good point.
Right?
Good point. Nice.
Good point, right? So as time goes by, after that window, for any of those full-time supervisor, right? And they have to somehow, start to really, going back and get some direct services. Otherwise, they will be precluded, in doing supervision.
That's a great point.
Yes.
I have to read that again, actually. I'm sorry, the requirement, just to make sure, but I think they could be supervising as part of that and not necessarily having been performing psychotherapeutic services. I have to go look at that just to make sure. But
to get it's basically for a supervisor, they have to have provided supervision or psychotherapeutic services into the last 5 years. So to get in the door as a supervisor, you have to be an experienced clinician. And then if you want to, if you maybe somebody gets older, they're near retirement age, they've been doing it supervising for a number of years. The law assumes they have that experience. We don't require them to continue to do psychotherapy. So I think that might be okay. It's just what's the wording that captures that? Right.
I think clinical services would be good. It's broad enough, and it's, I think it's broad enough. It's also narrow enough.
Christina, this is Sabina. Sorry. Also, I know Roseanne would be the expert on your Practice Act, but we have to make sure it's something like that is not defined somewhere else or already, used in other ways, at least those word clinical and whatever you decide to choose, we have to make sure it goes along with all the rest of our definitions or anything else in our Practice Act and doesn't, fly in the face of anything else or contradict anything.
Right. Yep. So it's about the consistency. So Roseanne, it's kind of like, that would be, just doing, just making sure that, the language are consistent. So it's, okay. Well, so go ahead, Roseanne.
Yeah, actually, Sabina makes a good comment because the law does say basically non-clinical practice consists of direct supervisor conduct, administering and evaluating psychological tests, writing reports, writing progress or progress notes, Clarence Center of Advocacy, and workshops. So since supervision is considered non-clinical, I don't think we want to use the word clinical services.
Yikes.
Yeah, that is a really good point. In terms of what other word we could use,
So it looks like that. Now, the other possibility is not to strike psychotherapeutic service, but just to change it, I mean, it's not to change it. Yes, it's narrow, but at the same time, the psychotherapeutic service, actually comprises and consistent, with all aspects for now.
so we would say provides psychotherapeutic services for the associate's employer.
Right.
So just simple. And that would encompass, so I'm trying to think out loud. So basically the person has to can be employed by or contracted by, and then they provide psychotherapeutic services, and that encompasses supervision for the associate's employer. So services.
So Roseanne, you just broke up, you just broke up quite a lot, when you were, talking about, you finished your sentences of, the legislative language.
Sorry.
No, it's the WebEx. Yeah.
Can you hear me now?
Yes.
Could you just
Can you hear me now?
repeat?
Okay. So I was saying that the language would basically say provides psychotherapeutic services for the associate's employer, and that would encompass everybody under that umbrella for that employer. So Kaiser would be considered an employer, and so if basically the supervisor for in this particular situation, Kaiser in their Permanente Health Group professional corporation would just need to be employed by or contracted by the associate's employer, and they would need to provide psychotherapeutic services for the employer in general.
Right. That sounds good to me. Yeah. So board members, any questions? Okay. So I see that, Josie, has a question mark, and so does Denise. So let's go to Josie, and our moderator, would you please help us out?
Thank you, Madam Chair. And Josie, you've been unmuted.
Thank you. So I'm just wondering if I would be able to just share an example that actually is quite personal to me. Would that be okay?
Yeah, absolutely.
Okay. Okay, so for me, I received supervision from an outside contractor while I worked for Kaiser to accrue my hours. What was set up was a letter of agreement, a number of kind of modules that they had to complete in terms of HIPAA compliance and confidentiality and kind of just overall Kaiser policies. That supervisor had to sign off on all of those things. Anything that was reviewed in terms of case notes and things like that, all the names were redacted, and the patient was their information remained confidential. So there were ways that we did it, but that supervisor did not work for Kaiser. They did not work for Kaiser, I repeat. So I could be losing my newly minted LCSW because I'm revealing this to you, but that's how we did it. And the thing of it is, and maybe this is too nitty gritty right now, but I was very careful about who I chose. I chose somebody who had medical social work experience. I didn't just kind of go to supervisor RS to, I don't know if that even exists, but to get my, to get my supervision, because I did, I totally respect the board's or the committee's concerns around, the efficacy and professionalism and the ethics that these supervisors might provide. But I do feel like I got a really good supervisory experience, but I guess the rub for me is that supervisor did not work for Kaiser. They did contract with Kaiser in the sense that they signed a letter of agreement. There was, this kind of documentation that connected them to us, and they were legally, there was legal obligation and there was a paper trail, but they did not provide any services for us in terms of allowing, in terms of that process.
Right.
So I would like to ask a question to Denise. Hi, Denise. So what you're saying is, because I know there are a lot of agencies that contract out, right, for a particular service. So you think, so this was the case, right? Just for my clarity.
So Max, are you speaking to me, Josie, who just spoke, or are you talking to Denise Tagade?
Sorry, to our last speaker, I thought it was Denise.
Okay.
Sorry.
No, it's okay. It's okay.
Okay.
Denise Tagade has much more expertise in certain areas than I do, but so I don't want to sideline her by any means.
Right.
So, yes, they do. So your question, sorry, is does Kaiser contract with other providers outside of the system?
Yeah, I'm sure they do.
Just generally?
Yeah, I am sure they do. So my question was, I don't want to go too much in the details, so I apologize. What I was saying is, so in our wording, when we are saying whoever, so in our word, it should be inclusive of those contracts relationship. They don't automatically bring home the fact that this is a person working for that institution, right? It could be just a small contract, an MOU, something that connects them. Like you said, there was a trail paperwork, which this person was referred out from Kaiser. So I wonder if in our language, we can reflect, to be inclusive of those experiences, we can reflect that kind of relationship. So we don't need someone that's really fully employed by Kaiser in this case, but someone that also has a relationship that's obviously formalized in terms of MOU or, contracting relationships. Does it make sense, Roseanne, what I was referring to? Tell me if it's not, huh? It's okay.
I think so. I think you're referring to, can we kind of honor these more like
yes,
smaller agreements?
Right.
Like the language as written does. I would just want to flip that and think, remind you that would work for Kaiser, but it would also work for a small private practice too, where somebody could have a agreement with an outside supervisor, and to provide. They have the written supervision agreement, and they can provide just supervision. That would be the psychotherapy services, and maybe that's okay. Maybe that kind of opens the door for better opportunities for supervision. But I think the board needs to weigh that.
Right.
So I think, Josie, the good thing now is that, that we really are collecting, the people's experience and also, the stakeholders' opinion. So the good thing is that we certainly, it's a two-way street, for certainly for the board, to consider, how we can, optimize, our regulations to, for public protection. But at the same time, also, now, before the regulation goes in effect, that really also give, the employers an opportunity to also how they can change their own practice, in order to, improve the, the quality of service, to help, with the interns. And so, so I think it's a wonderful two-way street. And, and so Josie, I understand how personal it is to you. And I, also think that, we will, and hopefully, by sharing, your opinion, that we can really just help, on both ways. So,
thank you.
You are very welcome. And so that, I absolutely, value your opinion. And I'm hoping that, at least, you can say that, I spoke up, and, Kaiser, hopefully you also understand that, the importance, of working with our intern and provide, the intern with the, down the road, when the law passed, be able to change their practice, how they hire, their contractors. Yeah.
Yes, yes,
Thank
yes. No, thank you so much for allowing me to just give my little vignette, but it really means a lot to me, and I
Oh,
think it also means a lot to the people standing behind me. There's so many of us that have been waiting to achieve a higher, uh, be operating on a higher level of skill sets than just the ASW, by achieving these hours, and getting supervision.
and absolutely. And Josie, I think, you provide a very good example that, because you need some supervisor, who actually have the medical experience. And so you are definitely on the right track. And also speaking for that particular group of the ASWs or the associates that, that I need somebody who understand my setting. Right? It's not just about the psychotherapy. And so I think, your advocacy hopefully can help Kaiser, or even, the Cedars-Sinai, be able to, to say that maybe we need to, just hire, in our category, or promote some of the social workers that got licensed, continue to work, and then be able to do supervision. So
That's the goal.
I am telling you, see, there you go. This is about advocacy, right? And so, I really encourage you that, I think this is going to be a good, good two-way win-win situation. So Josie, good job. Thank you.
Oh, thank you. Thank you so much for the encouragement too. I appreciate it.
Absolutely. Being a social worker, we believe in advocacy. So
yes, we do.
Yes, we do. So
yes, we can.
All right, Denise, go ahead.
This is moderator, and Denise, you've been unmuted.
Oh, great. Thank you. Yes, and thank you again for your responsiveness and for taking so much time on this particular agenda item. Just wanted to flag that I think, so the proposed change to the second clause there, that where you would have the same employer, actually brings us back to the same issue of having these, because of the way Kaiser's broken up into those three entities, TPMG, the Health Foundation, and the nonprofit, we would actually end up coming back to the same issue. And so that same site language is actually better for addressing that need. But just wanted to flag that, and again, thank you.
Thank you so much, Denise. Yes. And Steve, you have a comment?
Just quick, I was wondering, can we claim that that supervision is actually psychotherapeutic services, because you're actually doing the reviews of, the files and stuff? I mean, and we do have in here, there's a difference between, in our statutes, direct clinical supervision and then supervision of psychotherapy. I don't know, is there any way to spin it like that or no? What is the thoughts?
You will need to, ask Roseanne to see if you can tweak that supervision law.
We'll talk about it. And the other thing, just a quick thing, the MOUs and the contracts with outside supervision, I think, when we go through this process, we don't want to, do anything to preclude that. And I think that is the crux of what I think it's good public protection that we have those, because then that gives the Kaiser, whoever, if they have a supervisor that for some reason they have a contract, they can actually go back on and say, sorry, we can't use you anymore. So I think that's the crux of it. That's a really important part of it. And we don't want to.
Right. Roseanne?
Okay, I think Steve and also Denise, when they just both circled back just now, they made a really good point, is that we need to revisit the language in 2 a little bit. Because I think that Steve is right that the psychotherapeutic services, maybe we want to go a bit further and maybe say provides professional services. Maybe we define it as is defined in what's required for supervised postmaster's experience. So our people are required, and I'm just looking at LPCC law as an example, 1,750 hours direct clinical counseling with individuals, groups, couples, or families, and then 1250 hours in non-clinical practice consisting of direct supervisor contact, writing, evaluating tests, et cetera, et cetera. So maybe instead of, maybe we do it, instead of saying psychotherapeutic there, maybe we do a reference, for example, for we'd have to do a different reference for each practice act, but maybe we do a reference and say provides services described in 4999.46 C2 and 5. So basically we reference the definition of clinical and non-clinical services in the law in terms of what the person has to be doing for the associate's employer. So that's one thing. The second thing that Denise brought up, I think is a valid point, is that we still have that argument is technically Kaiser has the problem of the word associate's employer is too broad, and it is actually better for them for the same site to say the same site, but that's not, we need to get away maybe from the site. So it's like, how do we fix that?
Right. Yes. So, good question. So if you, okay. So the site is, definitely is an issue. So now, and for the associate's employer, that would also not satisfy, with the current Kaiser situation because of their contracted and they're not on the same site. Yeah. Sabina, do you have any suggestion? I'm coming to you because, it is more about, the languages.
Although actually,
Okay, go ahead.
maybe, here's another thought. So we would say something like provide services pursuant to 4999.46 C3 and 4 for the associate's employer. I mean, because we're allowing in subsection 1 them to be employed or contracted by, even if it's not, let's say that we had somebody at Kaiser nonprofit, Kaiser Hospital supervising somebody at Kaiser Permanente professional corporation, they're still going to have a contract with that associate's employer, the Permanente group, because the associate's doing services for Permanente group. So there's going to be some sort of an agreement with the supervision agreement is going to be in place. So maybe that's okay to say associate's employer because it's their employer that they have the agreement. Well,
I think the language is, because the difficulty, the language is that they are the, I think like Josie's experience is that they have, they basically have to find their own supervisor. And then I don't know if the supervisor agreement and stuff like that will kind of perceive as under that understanding, they can be perceived as part of, the, I don't know how the language goes because, they are affiliates, but they're not directly, employed, by the site. But that's kind of also, to be honest, and that's exactly the loop that we want to close out, and so unfortunately, I kind of find that, this is, I mean, I think Josie's experience exactly speak for, the problem that we deal with. And so, so really it's like, before, I think, this is important that, we try to really close that loop and then look at, how we, like Sabina said, our job is for consumer protection, coming from the angle that we need to train, the associates, by the supervisor who are actually qualified, and have the best knowledge, for their agency, And so I'm kind of feeling like that, it is an important thing that we have to stand on, and loop back that historical perspective, and that's exactly the things that we want to close out. And so, so that's why, I my hope, like I told, that Josie, that I hope that, Kaiser can hear this part of the conversation and really be able to consider that, that they have to change their practice, not just us, changing and caving for them, because we have our job to do, which is to protect our associate, to set the standard and also be able to, in order to really protect our consumers. And we want our associate be competent. So I'm kind of feeling that, maybe, we should not change, for the associate employer, and striking the site, because that's already partially, we already addressed the issues, when Denise was talking about walking across the building. And so, so that's just my take. I would love to hear from Deborah and for Wendy and Max and see what you guys think.
I'll go. I think that what you've said is absolutely spot on. And, we can't legislate for Kaiser, and we can't propose, for specific entities. I think that we're going to see healthcare continue to evolve and change into many, many different things. And so I think more than anything, we need to stick with what you had said, Christina, what our job is. And I think be kind of rest assured that we're also providing a roadmap for the future, which is always up for debate and always up to be looked at, just like we're looking at it today. But it's a roadmap for other people and other entities to design their healthcare so that they meet the legalities of supervision in this particular case. So that's, I think that, again, like Max, I'm going to go back to what Max said. It's got to be broad enough, but it's got to be narrow enough that it identifies our responsibilities, but broad enough so that it can continue to evolve and continue to move through all of the other different phases. But I think we're going to see healthcare, whatever we decide today or that the board decides, is up for grabs immediately after, because healthcare is going to continue to move forward, and we're going to see. But I think that it is important that we're clear on what our charge is. We need to be clear that we stand behind that charge, so that we give the playing field and those coming into it, those healthcare providers, a real clear picture and pathway of what the expectations are of the board. So it's not ambiguous and no one knows what we're doing.
Right.
So that's all I got.
Thank you, Deborah. And Wendy.
I feel like we have two pieces of the consumer protection aspect. One is, making sure that we have a qualified, we have a specific program that sets up supervision to make sure that the clinicians that are coming into practice are well trained and well qualified, and that is one piece. We also have a piece to make sure in an environment where mental health services are severely needed, there's a shortage of clinicians that can provide those services. And so how can we make the program work so that we can make sure that qualified people are able to provide services and that those hours count? So there's, two pieces there. And, we are aware of this issue. It needs some clarification, but it doesn't feel like we're going to get there right now today in this meeting with what the specific language should be. Because every time we offer a word here, so I almost feel like kind of circling back to, Roseanne, I know you wanted some more specific direction, but it almost feels like at this point, could our direction to you just be continue working on this with the stakeholders, and at the March meeting, maybe there's a new proposed language that comes to us then that we're not thinking about here? Because I feel like this needs, a really focused conversation that I don't know we're going to be able to get to today.
Mm-hmm. Roseanne, go ahead. You have your hands up.
I think we've actually made a lot. It's a lot clearer in my mind the direction we want to go now. So I think the direction is we're looking at option 2, and we're looking about deleting the if you're already licensed by another government entity, that you can be considered a non-clinical practice. So we're really focusing now on the language in number 2, and I think that I can work with the stakeholders and kind of look at the language in the law and come up with some options for that particular piece, and that we can have the bill move forward that way. So yeah, I think that we can. I mean, right now, what I'm kind of thinking is provide supervision pursuant to, and then reference or list the activities for the associate's employer, and then maybe come up with a couple of other options instead of using the terms associate's employer.
Right. I think it's really about the language now, because I think the concept, that, and the information from the public were very, very clear, about the direction to go. And so at least, we can strike down option 1, option 3, we open the door, for conversation. And so I think this is good. So, now I just want to wrap it up, because I know that this is going to be the longest discussion. And so let's wrap it up and then see if, that Roseanne, whether you feel that, there's a motion on the, there's a motion on the table. It is certainly a work in progress between now and the 3rd and March board meeting. But I think we should be able to vote for at least, to adopt option number 2, and also to adopt the language of the number 1, and then for the number 2, to also, adopt the language for the supervision in pursuant of whatever, all the reference, then continue to work on for the employer, and then see how you can carve out, that section of it. Right.
Exactly. I think that's a great direction.
Right. So, so Sabina, do we need a motion?
So are you wanting staff to bring this recommendation to the full board, or would you like it back to the next committee meeting before it goes to the full board?
Roseanne, what do you think? Because it is a legislation package, right?
The problem is that we've got the bill that's about to be introduced. So for the bill, we really need other portions of the bill. So I think if we're pursuing option 2 and we delete that part about the government entity certification, even if it takes a little while for us to work out the language in 2, that buys us some time for the bill, or we can commit to working on it in the telehealth committee if we don't get it perfect there. So I think that allows the bill to continue to move forward, but I think we need to be committed to striking that first part.
Right.
Because we don't want the part about the certification or licensing from a government entity, because we don't want the bill to move forward with that. I think that will cause some unintended problems, and then we can commit to working on the rest, hopefully this legislative session. And if for some reason we can't come to a perfect solution, hopefully we can still get the board and then continue to work on that piece, because it's still affected by the telehealth committee. Does that make sense?
Yes.
Yes.
Okay. Yes. So now, when is our next telehealth committee meeting?
March, I want to say March 28th. It's either the 26th or the 28th.
Okay. So then I'm thinking that, now I just want to make sure that, it fits with the legislative cycle.
It might not fit with the telehealth committee right now, because the telehealth committee is just getting started. What I'm saying is, if we delete that part about the government entity and we work on amending 2,
okay,
subsection 2 about the associate's employer, we can start that. If we can't get it perfect this year, my hope is that we can still get the bill, or leave it as originally proposed, and then commit to continuing to work on that piece.
I like that.
Hopefully we'll be able to figure it out in time for the bill to be amended. But this bill is really critical for a lot of other entities, other areas of our law that we're dealing with issues. So we really need to get the bill moving forward, but we also really need to correct this piece. But
right.
This piece might play into some of the telehealth committee too.
Absolutely. So, so in a nutshell, it's going to be definitely a work in progress. So we
Yes.
have to move forward, whatever we have, and
Yes.
be able to, just get that off the table and continue to have that conversation. So then the question would be, are we all comfortable, with, what Roseanne proposed? Added the language of number one. Okay, option two, add the language of the, the amendment, for the, it will be like what, the clinical services, in reference to, all in reference to the language, and then keep for the associate employer.
Can I actually, can I say it a different way?
Sure.
Okay.
You're the expert.
My motion would be to pursue option two, and proceed by deleting the certification clause in 4980.43.4, and then the corresponding sections for LCSW and LMFT, and then also continue to pursue options to amend that subsection 2, which is in, let me see, that's going to be 4980.43. Hold on just a second, I'm not finding it. 4980.43.4 B2 and its corresponding sections in the other practice acts.
Okay.
Does that make sense?
Yes.
That would be a recommendation to the full board.
Yes.
So I will make that motion that Roseanne just said.
I'll second it.
And Deborah second. So any other discussion? Board members, public?
I just wanted to concur with everything that's been said. I'm in full support. So yeah.
You can show your full support by your vote down the road. Thank you, Max. Any other discussion? And thanks for your comment. Okay, seeing none, then I think we're ready to vote.
Okay, I have a couple of questions. Roseanne, I got most of what you said. However, in the early part of that motion to delete the certification piece, you referenced a section. Can you repeat that section number, please?
4980.43.4B, and then also the corresponding sections in LCSW and LPCC law.
LCSW law, okay. And then after we do our motion and our second, are we opening up for public comment one more time or just going straight into voting?
That would be my preference. This is Sabina. One more time on public comment on the motion.
Hi, this is the moderator. I can go ahead and open the Q&A feature. All right, the Q&A feature is available. If you would like to make a comment, please type, "I would like to make a comment," using the field in the lower right-hand corner of your screen, and send it to all panelists. We are displaying instructions for your reference. And Denise Tugati would like to make a comment. So Denise, I'll let you know when you're unmuted. All right, Denise, you're unmuted.
Thank you. And thank you so much to our board members and to our board staff. Again, wanted to just express my thanks for your continued work on this and appreciate your very thoughtful consideration, and looking forward to continuing to work with you.
Thank you so much, Denise. We love to have your feedback to make it perfect. So Roseanne.
Yes, I just wanted to say on the motion, I need to make a correction. When I talked about deleting the certification language and the licensing language, it's not, so the section is 4980.06A4. So Christina, 4980.06A4 and corresponding sections. So sorry about that. I've got too many code sections flying around.
I got that, thank you.
Great. So moderator, any other comments?
Thank you, Madam Chair. Josie Baker just typed that she was wanting to give thanks for all this work and consideration.
Oh, thank you so much, Josie. We love working with you too. Awesome. So any other comments? Let's see. Doesn't look like it, moderator, right? Just confirm.
That is correct. Would you like me to close the Q&A panel?
Sure. All
Okay, I
right.
will do so.
Okay, thank you. So I think, Christina, we are ready to vote.
Okay. Deborah Brown,
Yes.
Max Disposti,
Yes.
Wendy Strack,
Yes.
Christina Wong.
Yes.
Motion carries.
Thank you very much. Let's take a quick break. So now is 10:24. Let's resume on time at 10:35. How about that? 11 minutes break. We'll see you soon. Resume our meeting, and thank you very much. We are starting exactly back at 10:35 a.m. for our BBS Policy and Advocacy Committee meeting. And so let's move to our agenda number 4, and that is the discussion of a new term, prognosis versus treatment planning. So Roseanne, take it away.
Yes. So this is a discussion we had about 2 years ago now. In the 2019 Omnibus Bill, which was SB 786, and it was signed into law, the board sponsored a technical amendment to amend certain business and professions code sections relating to LMFT and LPCC required education. And this is referring to the education required in the qualifying degree programs. Previously, those sections, which they discussed required education and practicum for LMFT and LPCC licensure, required coursework in assessment, diagnosis, and prognosis. The board decided to propose an amendment replacing the term prognosis with the term treatment planning, because it believed that treatment planning was the more accurate representation of the course of psychotherapy. So that change was successfully made, and it became law via SB 786. However, now that it's been law for a while, stakeholders have alerted the board staff that based on some recent discussions that they've had with other mental health professional entities, that they may be interpreting the board's law change as meaning that LMFTs and LPCCs are not permitted to perform prognosis. And I don't believe that that was the board's intent when it decided to pursue the law change. Dr. Ben Caldwell was nice enough to send a really eloquently worded email that explained perfectly the issue that they're encountering. So that's shown in attachment A. And then I have drafted, should the board decide to proceed with adding prognosis back into law with treatment planning, I have drafted some language that would show the amendments that would require. So at this point, I want to open up the discussion so we can see how everybody feels about this.
Thank you so much, Roseanne. And this is a perfect example that the law will always circle it back, when stakeholders sees that, there are things that we need to get done. And so thank you so much, Roseanne. And thanks, Ben, for, alerting our staff that, and giving us the explanation, why prognosis is important. So the discussion is actually very simple. It's really about do you feel that prognosis needs to be added back into the legislation, for the required coursework, for the LMFTs. So any discussion from the board members? I don't see any. Oh, Max.
I do actually, sorry. So obviously as a public member, perhaps my colleagues that are licensee can actually help me to understand this, because I don't see that problem. And I like the idea of a treatment as more an idea. It's more broad, and in my personal understanding, prognosis comes also with stigma and almost pathologizing whatever these dynamics are. I might be wrong again, so I apologize with my licensee, also, whoever brought the concerns to us. But I would like to know a little bit more how this has affected or limited our licensees in their practice, because obviously that, like we said, that was absolutely not the intention of the board. So I don't understand how that change of word might have limited some of the licensing interpretations of giving prognosis with, which obviously is part of their responsibility as well, right? So yeah, can anyone help me with that?
Roseanne, do you have your hands up? Was it an old hand? Roseanne, you're muted.
Sorry, that's an old hand. So I will let the stakeholders kind of speak to that before I do.
Absolutely. So let's finish with the board members, and then we can open it up to the public. For maybe Ben can speak for that and answer Max's question. Deborah or Wendy, any comments so far? Okay, go ahead.
Along with Max, I think I'd like just a little bit more information about what that does and doesn't mean.
Okay, sounds very good. And Deborah, you? Same? Okay, so moderator, would you please open up the public comments?
Thank you, Madam Chair. And I have opened up the Q&A panel. So if anyone would like to make a comment, please type "I would like to make a comment" in the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions for your reference. Okay, so we have an individual identified as Ben Caldwell that would like to make a comment. Ben, I'll let you know when you've been unmuted. And Ben, you've been unmuted.
Wonderful. Thank you very much. And board and staff, I appreciate you taking the time on this. It is, thankfully, I think, not nearly as complicated and difficult as the last issue that you've been working on. But yeah, so the concern here is primarily what was in the letter. The two particular examples that I gave, one being MFTs and others as well. I think this impacts counselors, as I recall. But MFTs who are called upon to provide expert witness testimony are often called upon to make some kind of a prognosis, which serves to kind of outline their expectations for the future course of an individual's mental illness or their diagnosis. And then the other example being, we have lots of folks who in various work settings do discharge summaries or other summaries of treatment that would include a prognosis that is not necessarily done in the context of planning for future treatment. We want to make sure that those things are still clearly within the scope of practice of an MFT. I don't think it was the intention of the board to have those not be within our scope of practice. Max, your concern about stigma is certainly well placed. It's one of the things that I think responsible MFTs always keep in mind when we're issuing any kind of a prognosis or discussing somebody's potential future. We try to be very cautious about anything that would be that would sound determinative. In other words, someone's prognosis is always dependent on what they do next. Do they remain in treatment? Do they remain med compliant for those who are on medication? And so I think good responsible MFTs are cautious about their languaging of that kind of thing. So I'm happy to address any questions. I appreciate your taking this up.
Yeah, I'm sorry, Madam Chair. Can I ask a question?
Go.
Ben, thank you so much. That's definitely already helpful. So in my understanding, I always read prognosis and treatment planning as two different elements, right? Because one doesn't necessarily contain the other. So I never seen one replacing the other. So again, it might be my problem with interpretation, but to me, assessing a dynamic, right? In this case, a mental health dynamic doesn't automatically include a treatment plan and vice versa. So I'm also concerned that replacing the term might actually exclude the other aspect of interventions that clinicians obviously is due to do with their clients. So can you explain that to me a little bit? Because really, I see these two terms as two different aspects and not one replacing the other.
I think you're absolutely correct, and the intention here is not to replace one term with the other, but rather to make sure that the language going forward includes both.
Okay, I love that. That really clarifies for me. Thank you, Ben. Thank you so much.
Thank you.
So Wendy, do you have any questions for Ben?
No, I think that was helpful for me. Thank you.
Awesome. And Deborah? No question for Ben. So Ben, you did a really good job today, satisfying our need for information. And so in that sense, so basically it will be adding, the language. It's adding the word prognosis, in the existing language, so it will be, you will have prognosis and treatment planning together. That is good update. And so also,
I'll make a motion to approve. Oh, sorry.
Okay, go ahead. Make a motion.
Yes. I'll make a motion to approve. I don't know how Sabina would like to word that, but insert the word prognosis versus treatment planning into the bill.
Right, and we would be making that motion would be making that recommendation to the full board.
Yes, correct.
Okay.
Thank you, Sabina.
Do I have a second? Oh, Wendy. Wendy, second. Okay. So for this time, I'll open up for some more discussion. And looks like Jen Ellie. So you have your hand raised.
Hi, this is the moderator, and Jen, I'll let you know when you're unmuted. All right, Jen, you've been unmuted.
Oh, thank you very much. This is Jennifer Alley with CAMP. I had raised my hand prior to the motion being made, but I'd like to thank the board for their consideration of this issue, and I would just align our comments with Ben's. Thank you.
Thank you, Jen.
Thank you, Jen, and my apology for not seeing your hand raised, but at least it's not too late. So awesome. Any other discussion from the public? Moderator, do you see anybody else?
Thank you, Madam Chair. I do not see any other requests for public comment. And for folks that have raised their hands, just a reminder, if you click the hand icon a second time, that will lower your hand. But at this time, I see no more comments. Would you like me to close the Q&A panel?
Sure, that will work. Thank you very much.
You're welcome.
All right, so I think we're ready to vote. Christina.
Okay, Deborah Brown. Is Deborah here?
Deborah. Yeah, we haven't seen Deborah. Okay.
We'll come back. We'll come back to her. Max Disposi?
Yes.
Wendy Strack?
Yes.
Christina Wong?
Yes.
One more time. Do we have Deborah Brown? That's okay without her. Oh, Deborah, there she is.
Deborah's right there.
Is that a yes or a no?
Yes.
Thank you. Motion carries.
The WebEx really takes a lot of my computer, so sometimes it just blacks out. So just if I disappear, I got to try to get back.
Okay.
Motion carries.
Well, thank you very much. Sometimes, we don't like our life hinged upon, the technology, the power of the technology. So thank you so much for the last discussion. And so let's move forward for the next one, which is the CAMP bill proposal to modernize and clarify LMFT scope of practice. And I believe it's Roseanne again.
Yes, so CAMP has approached us with a bill proposal that they are in the process of planning on finding an author for. They would like to pursue a proposal this year to modernize and clarify the scope of practice for marriage and family therapists. So in the memo that you see here, I've included section Business and Professions Code section 4980.02, which is the current MFT scope of practice. In looking at the history of this section, it was last amended in 2010, and only minor technical amendments were made at the time to correct some code sections. The next most recent amendment after that was made in 2004, and that amendment at the time was made to include the use, application, and integration of the coursework and training required in the degree to the LMFT scope of practice. So basically adding the last section basically is saying if your coursework, if it's the required coursework includes it, then it's in your scope of practice if you're competent in it. So it's been really a long time since the MFT scope has changed. Almost 20 years since the last substantive amendment. So CAMP is seeking to modernize and clarify the scope. The amendments that they intend to introduce are shown in attachment A. They went through the MFT law in writing this proposal. They went through the MFT law and looked at what's required in the education and experience. And so when you see on the bill proposal, you can see that when you see a term that's used, they have a corresponding reference section where that's can be found somewhere in the education and experience. And they've also provided a attachment B, which is a matrix of reference statutes, which basically does the same thing, but it's in an easy to read Excel chart form. So I wanted to open it up for discussion now, and we can go from there.
Thank you, Roseanne. And I want to just thank, Kempf, that matrix, it's amazing. That is very, very thorough, when you, refer to, the language and just cross-reference with, the languages, that you're, from the legislation. So thank you so much. That was really good work. And so board members, any discussions, so it's really focusing on the attachment A, to see the updated languages. So board members, any questions so far, or should I open to the public, and Max, go ahead.
Just a quick comment. I was really, thank you to the colleagues at Camp. I was really happy to see that, to bring it to the 21st century, because this is actually the reflection of what the description describes correctly what the licensees are doing specifically. I think it's really up to date with what the reality is. So yeah, I'm very happy to see this.
So, so it's an interesting thing that, since we were talking about like adding the word prognosis, and it's there. And then since we have the treatment planning, it's there. So Ben, good work. And so, so Jen Ellie, I saw your hand up. And so I think, board member probably would not oppose me, to open up for the discussion and hear a little bit more from, from you all, and just to give us a little update, why you have that's need to, why, where that, the thought of updating, modernizing the language, or give us, and walk us through. So moderator, would you please open up? And I see you open up for the public comments.
Thank you, Madam Chair. I will go ahead and open the Q&A panel. So if anyone would like to make a comment, please type, I would like to make a comment, using the field in the lower right-hand corner of your screen, and submit it to all panelists. We are displaying instructions for your reference. And Jen Alley would like to make a comment. So Jen, I'll let you know when you've been unmuted. And Jen, you've been unmuted.
Thank you. Good morning. This is Jennifer Alley with CAMPT again. And at first, I would just like to thank Steve and Roseanne for their incredibly helpful feedback, along with the other stakeholders, including the National Association of Social Workers California chapter, the LPCCs. We met with a psychiatrist, psychologist, the California Hospital Association, the Medical Association, and many others like Ben Caldwell and Olivia Lowley, who reviewed the draft language and provided us with feedback and recommendations. We took those recommendations, and we really think that it helped to strengthen and clarify the draft that's in the agenda before you today. The changes that we've taken have resulted in no opposition from those associations, and some support from other stakeholders. As you know, and as you've seen in the agenda, the current MFT practice statute contains an oversimplified short description of MFTs, and really, refers to other statutes rather than clearly specifying what the MFT scope of practice is. And so to address this, about 4 years ago, the CAMP board established a scope of practice task force of clinicians tasked with evaluating and reviewing the existing scope. This task force reviewed the current scope, analyzed the scope in other states, and evaluated the diverse education therapeutic terms utilized and included the current educational and training requirements. And so, you know, we included the matrix in your packet that we sent to Roseanne to reference the existing statute and to, you know, assist you in your review of our proposal. We have secured an author, and that will be Assembly Business and Professions Committee Chairman Evan Lowe will be authoring our bill. And you know, I'm here to answer any questions that you may have, but we do respectfully request, you know, the committee and BBS to support our effort to modernize the scope of practice for MFTs in a way that reflects the education and therapeutic concepts and treatment regularly utilized by MFTs.
Thank you, Jan. And so, and I see Kathy Atkins. And moderator, would you please open her up?
Thank you, Madam Chair. And Kathy, you've been unmuted.
Oh, great. Can everyone hear me?
Yes.
Okay, great. I just wanted to reiterate and ditto to what Jen said. Just a huge thank you to Roseanne and Steve and the BBS who really were able to give us some great guidance and pointers. Ben Caldwell, who's on the call, same with him, Olivia Lowy, many different clinicians over the last 4 years from CAMP of all different walks of life and professions and just stakeholders, just everyone that Jen said. I wanted to take the time to thank and appreciate all those people involved. This is incredibly important to CAMP. As an aside, I haven't worn lipstick in 8 months and I put it on today and no one can see it. But just so you all know, this is how important it is that I have lipstick on. So if you could see me, you would see that I have it on. But this is so important to us and we're just so appreciative. And I didn't want to not take the opportunity to thank everyone, especially Roseanne. So thank you. That was it. I just wanted to echo Jen's great words. Thank you.
Thank you very much. And Kathy, so bad that we cannot see your lipsticks. But it's okay. You know, we will have to wait until, you know, we have the in-person meeting. Thank you. And so Rebecca, I also see her, you know, she has a question. Moderator, would you please open her up?
Of course. Rebecca, you've been unmuted. And Rebecca, you're really faint. So if you can get closer to your computer, your microphone maybe.
How about now? Is that better?
Yes.
Okay, great. Rebecca Gonzalez, National Association of Social Workers, California chapter. Probably a good thing you can't see me now. But anyway, we just want to say that CAMP did reach out to us early on in the process. We've had a number of conversations starting in the fall. We did make some suggested changes to their original language, and we were able to agree on the final language. And so we will be neutral when this bill is introduced, and want to thank CAMP for the open process that they had and the number of discussions we had on this bill.
Okay, very good. So looks like Ben Caldwell. And
Yes.
the moderator, yes, please.
All right, Ben, you've been unmuted.
Thank you so much. I just want to, Ben Caldwell, MFT, I just wanted to voice support for the proposal here. I think on a process level, what Jen and Kathy and CAMP have done has really been a model for how to approach this kind of a change, working actively with stakeholders over a long and thoughtful period of time. I think it's important to emphasize too that from a clinical perspective, you know, this is not either intended or languaged in such a way as to be an expansion of scope. It's really more making the language more current and more clear, reflecting what MFTs are already doing in clinical practice. So with that, I would just say thank you, board members. Thank you, Jen and Kathy from CAMP, and encourage support for the proposal. Thanks.
Thank you very much. So, let's see. I'm so thankful for, for the stakeholders, to really, practice, just, really consulted with each other, and with the staff and, even with the peer association, to come up with this language. And so, and looks like, this is going forward, and this is, and also I'm glad that, you guys find a, find the author also. So we will be seeing this, down the road. And so I think this is a wonderful opportunities too, for our board members, to give the feedback, any of the things that we see, that can, help camp, to submit this, submit the possible changes, to make it even better. And so, wonderful. So now hear from the public, any comments from the board members? Go ahead, Deborah.
I just like to follow up with what you just said. A thank you to the stakeholders. Must be all the news, the GameStop stuff. Anyway, I think this really speaks, though, to the positive relationship that and the long running, how do I say this, employment of our staff members that are so vested in this board and the stakeholders, the having that positive relationship, especially with our staff and the stakeholders, this is the result. It's not catching each other off base or having to play catch up because we don't know how it's all evolving in the field. But this is constant give and take back and forth that I think makes the board and our stakeholders so strong. And I know my time is going to be up in June, and looking back, all of the positive relationships have really made this board's job easier. And I think made the stakeholders feel that they really do have a voice and able to talk to us, and that we both of us move forward in a very positive way. So I think this is a real good example of that.
Yeah, wonderful, wonderful. Max?
I just wanted to, definitely reiterate my support. I think this is really long overdue. I just a little curiosity. I don't know if our stakeholder can answer that. I was wondering if in the conversation, the name of marriage and family therapist ever came up in terms of how sometimes the appearance to be just that, right? Restrictive it is versus the actually broader spectrum of clinical services or interventions that it's provided. So I wonder if it was ever came up in the conversation, the idea of even revising that, the name, the marriage and family per se. So I was just curious. I mean, so if anyone would like to address that, or if it is even a problem, if it was brought up.
Nice.
This is the moderator. We have two members of the public that would like to respond to that. The first being Kathy. So Kathy, I'll let you know when you're unmuted. Kathy, you've been unmuted.
Hi, sure. Thank you, Max. The question you're asking actually is a question that comes up. Interestingly, I would say a large portion of our therapists do struggle with the name itself, and a large portion of our therapists feel very, very strongly about that title protection. And so certainly we've heard that question before, and that conversation is not it's not going away. It's a conversation we continue to have. But again, there's a large portion of the MFTs that feel very strongly about the title and what it means and the systems approach it comes from. However, we thought the scope definition was definitely the priority and something that basically every MFT could get on board with. So that's why we made that a priority. Thank you.
Very good. Very good. And moderator, there's some more, right? Some more people.
Correct. Ben, you've been unmuted if you'd like to add anything more.
Yeah, thank you. Kathy said far more diplomatically what I was going to say, which was that, yeah, lots of MFTs feel very strongly about the title in all different directions. I mean, there are some who feel very, very strongly in support of the exact title in its exact form that it exists today. There are others who feel very strongly that it's not the ideal reflection of who we are and what we do and would love to see some kind of a change. So that's a whole different can of worms to open, and probably a much more controversial kind of discussion to get into. The scope language that's being proposed here is, I think, much more likely to garner widespread support because it's not such a controversial change.
Yep. It totally makes sense. Thank you, folks, for answering. I was just curious because I do serve in my agency. I have very quiet young therapists that absolutely have this sense of patriarchal presence, and that name they don't feel associated with, right? So it's interesting to watch. It could be a generational, take as well. So I was just curious, but thank you for answering. I don't want to distract the public from the sense, the great, changes that this bill is proposing, which I fully support. So thank you.
Right. Very good. And so, moderator, anybody else? I see two hands, so I don't know if they are. I see Jen Ellie, who hasn't spoken, so I don't know if that's the old hand or the new hand.
Thank you. I'll unmute Jen and we can find out. Just for folks who have raised their hand, that's not something the moderator can do. I can't lower someone's hand. Oh, Jen just lowered her hand, so I suspect that was from another time. Kathy still has her hand up, but I know she spoke. So just to lower that hand, you just need to click it a second time.
All right. Oh, okay.
Okay.
Wonderful. And so, so I just really love this collaborative process that I have seen, with Campton, with everybody, with all the stakeholders. So in this sense, we are their stakeholders. And so they're reaching out to us and say, hey, give us feedback. So thank you so much, so that we have this conversation in, in the P&A meeting. And so, so I don't see any of the board members have question or any recommended changes for the, for the proposed language. So can I safely say that, I need a motion to...
I'll make a motion.
Okay, and I need a second.
The motion will be to direct the board to adopt the proposal, which is the bill number. I don't see it now. I apologize. But anyway, yeah.
Max, the board will not be making this proposal. This will be to support CAMP's proposal.
Oh, to support. Okay. Thank you.
We're recommending that to the board.
Right.
And Deborah, second. Okay. So any further discussion? Board members? Seeing none, and the public?
Thank you. This is the moderator, and I can go ahead and open the Q&A panel one more time in case anyone has any comments to add.
Seeing none too. Very good. So I think we're ready for voting. Christina, please.
Good. Deborah Brown. Okay, I got a yes for her. Max Disposti.
Yes.
Wendy Strack.
Yes.
Christina Wong.
Yes.
Motion carries.
Thank you very, very much. So our next agenda item is, is some reports. And the first one is about the updates on status of the board-sponsored legislation. So I believe it's Roseanne.
Yes, the legislative update. The board is currently sponsoring 2 legislative proposals this session. Legislative proposals are still in the process of being introduced. The deadline to introduce them is, I believe it's sometime near the end of February. So we'll continue to see those rolled out, and we're monitoring all introduced proposals. The first bill proposal that the board is sponsoring is going to be our practice setting definitions bill, which we had that long discussion about early in the meeting. Assembly member Arambula has agreed to author that board sponsored bill again this year, so that should be introducing soon. And then the second proposal is the omnibus bill proposal, which is the technical, non-substantive minor changes every year that the board it does its kind of cleanup language. That's always that bill is always run sponsored by the Senate Business Professions and Economic Development Committee. So we have submitted the items that the board approved at its November 6th meeting to that committee, and they are going through and determining which ones that they will be willing to run in the omnibus bill. So look for that soon as well.
Very good. Thank you so much, Roseanne. And then I think the next agenda is the report on the status of board rulemaking proposal. And I don't see Christy here, so I suppose it will be Roseanne.
That's going to be me. So we have several rulemaking proposals that we're currently working on. First, I'm happy to announce that our AB 2138 regulations have been approved. That's the substantial relationship and rehabilitation criteria. The effective date was December 14th, 2020. So the new language that was approved, we've updated our FAQ on the website for the 2138 FAQ. We have an FAQ for those applicants affected by that. And we've also updated it in our new 2021 Statutes and Regs book, has the new sections. So those are, that book is now available online. And also if you want to see just the regulation proposal as it was proposed, under the regulations section on our website, that is there under approved regulation. So happy to announce that. Our enforcement process regulation, which was a proposal we had been pursuing a few years ago to update our uniform standards and disciplinary guidelines, that proposal is on hold right now. Now that the AB 2138 regs have moved forward, this proposal affected some of the same sections, so we couldn't run both at once. So Christy is going to be in the next several months working with our enforcement. It was approved by the board many years ago now, and we have pretty much mostly new board members. So, and probably new issues that have been raised in terms of enforcement and uniform standards. So we need to do another review of that proposal and then bring it back to the board, and then we plan to move forward with that. Our supervision related regulations that has been submitted to OAL for final approval. We are hopeful that we might be able to get a July 1st effective date, but that remains to be determined. So that's not for sure yet, but that is what we are hoping for. We also have a regulation package that's in the initial review process. That is the continuing education and additional training requirements regulation. And then finally, the exam waiting periods, professional corporations, and accrediting agency equivalent degrees proposal. We're in the process of preparing that to submit it for BCA initial review. So a lot going on the regulation front.
Right. Yes. And it's a lot slower process, but at the same time, it is what it is. And I'm very glad that at least, that we have a set of the regulations are, being approved. And I'm really hoping that, supervision packet, will be approved soon too, because that would also affect many of the supervisors and also supervisees. So thank you so much, Roseanne, for the very, very comprehensive report. And so then I think we're coming to the very end, and that would be the suggestion for future agenda items. And moderator, actually, you can also open the public for the public comment. But before we do that, I would like to go to the board members first. Any of the suggestions for future agenda items? No, Max is ready to give her his 2 thumbs up. I like to tease Max. Okay, seeing Wendy, no. Deborah, no. Okay, awesome. And I have none too. And then I think moderator, would you please open for the public?
Thank you, Madam Chair. All right, if anyone would like to make a comment, please type "I would like to make a comment" in the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions for your reference.
So I don't see any of the hands right now.
This is a moderator, and I am not either. Would you like me to go ahead and close the Q&A panel?
I think that would be pretty safe to do so.
Okay, it's closed.
Thank you so much. So, like I always say, our last agenda item is adjournment, which is our favorite one. So the time now is 11:15. So, we will be officially close the meeting. And I want to thank you all for participating. What a wonderful discussion and fruitful collaboration. So I will see you all in our next meeting, which will be possibly, I think it will be the board meeting.
Yes.
March 3rd and March 4th and the 5th. Yes.
Yep.
So thank you all so much and have a wonderful day. Have a wonderful weekend.
Thank you, Christina.
You're so welcome. Bye.
Thank you.